Sure. I'm really bringing us full circle to the beginning, to Professor Dreyfus's remarks, which really anticipated a lot of what Shuba and I have put in our paper for the symposium. And so we use the really fascinating, I think, and useful framework that she developed with Professor Dinwiddie. I recommend the series of articles in the book that led to it, that spell out her neo-federalist vision of TRIPS. And we analyzed the Eli Lilly case in terms of that theory. In the interest of time, and because we've already been there this morning in both her presentation and in Shuba's, I won't go into the details of that framework. But instead, I will jump to the middle, what was to be the middle of my presentation, and present or briefly run through three of the larger points that we make in our paper about the Eli Lilly case. I won't close with any suggestions for how to reform the system. I think that Rob has already done a great job of suggesting some, and in fact, I don't have any in my paper or in our paper with Shuba. But I fully agree that the tweaking the text and adding annexes and for greater certainty provisions is certainly not an effective way to deal with the problems in the system. So 3 points that we make in the paper. First, we argue that allowing investors to litigate the meaning and application of international IP treaties or law in an international investment law setting has a quite problematic consequence of placing the interpretation and application of IP law in the hands of adjudicators who know nothing about international IP law, as they fully admit. And these are people that have little incentive to actually get IP law right. International investment law arbitrators are almost always selected by the relevant parties for their expertise and reputation in the highly specialized and elite world of international commercial litigation. They are mercenary commercial litigators. That was the case in Eli Lilly, and it's not surprising then to note that none of the arbitrators in that case had any expertise in IP law, despite spending a lot of time addressing Canadian IP law in the award. Second point, international investment law, as investors claim it to be, in my view, fetishizes legal certainty and exaggerates the inability of potential investors to plan around uncertainty or their willingness to invest in the presence of uncertainty. And so this fetishization of uncertainty results in an almost comical hypocrisy in the Eli Lilly case. And so Eli Lilly makes a huge fuss in the arbitral proceedings about the company's exquisite sensitivity to legal instability and of Canada's deviation from an allegedly globally uniform IP law. But here's the hypocrisy. In Eli Lilly's official communications to investors, which I cite in the paper, they routinely emphasize to their shareholders and potential shareholders, as they have to under SEC regulations, that legal instability and a lack of uniformity are an inherent and inescapable part of the world in which they do business, and in which they regularly earn billions of dollars in annual net income. Moreover, and I think this is probably even more hypocritical, Eli Lilly was castigating Canadian courts, which are ranked extremely highly in terms of the quality of law that they provide, castigating them for their supposed inability to fairly manage and apply the allegedly vague legal standard of the promised utility doctrine, right? While at the same time they were saying, how in the world can we trust Canadian courts to fairly apply this vague doctrine, they were expressly entrusting the arbitral tribunal to fairly manage and apply an equally, if not more vague, standard of international law. And what's that? It's the standard of fair and equitable treatment, right? And so note the irony. Promise utility doctrine is too meaningless for judicial management and application by professional judges working in a high-quality domestic legal system. If that's the case, then so too presumably should be the extremely mushy international law doctrine of FET, upon which Eli Lilly really based its case. We talked a lot about expropriation. Expropriation is not the game in this town. The game in this town is FET. And here's another, I think, hypocrisy or irony. So Eli Lilly is not only more comfortable with the IIL tribunal, so inexpert in IP law, amateurs at judging, applying a contentless standard. It was comfortable with the arbitral tribunal doing so in a legal environment which, as Eli Lilly emphasized in its pleadings, an atmosphere in which the FET doctrine itself continually evolves through a common law process. Eli Lilly wants FET to evolve constantly through a common law process because they see that the system is pushing FET in a pro-investor direction. At the same time, evolution of domestic IP law in a direction that disfavors Eli Lilly's rights is viewed as being beneath the pale, below the international law minimum standard. And so I find that contrast, I think, quite striking. Third point, and this is the last point. We note in the paper that international investment law is often justified as providing a low-cost, efficient, depoliticized method of investor-state dispute settlement. As the Philip Morris case shows, arbitrating IP disputes can be hugely politically controversial. Eli Lilly, outside of IP circles, wasn't really all that controversial because I think it was a highly technical case involving the promise utility doctrine, not super scintillating. But Eli Lilly does show that these cases can be hugely time-consuming and expensive. And so how long did it take? Over 4 years from start to finish. The claimant alone submitted nearly 600 pages of submissions, 545 exhibits, 22 expert reports, and witness statements. The process produced over 90 publicly available documents on the docket. It included 8 days of hearings and an astounding quantity of witnesses and interveners. You had 6 amici presenting their views. You had a battle royale of experts and counter-experts offering opinions and reply opinions, and even reply-to-reply opinions. And so both sides spent copious amounts of money. The company's total expenses, most of which went into the pockets of Covington and Burling, the white shoe law firm, $9.43 million. Canada spent a lesser amount of money, it was quoted before, accurately as about $5 million US, specifically it was 5.9 million Canadian. But most strikingly, besides the money that Canada spent, the case consumed for Canada alone 20,000 man-hours of legal work by government attorneys and by paralegals. And that's not including the time billed by any of Canada's numerous experts or the services of outside counsel or other consultants and contractors. I was going to embarrass your professor and advisor and point out how much he made by being an expert. I will say it is publicly available in the cost submission, and at least in Canadian dollars is more for writing two relatively brief reports, and I'm sure other things, more than a federal judge makes in an entire year. We will discuss. We will discuss. No, he can tell you a lot more work was involved in what he did, I'm sure, than writing than what is than the briefs that were submitted. But there's a lot of money to be made by a lot of people, and so I think, as Rob was saying, it's important to recognize how money, I think, influences the development of the system. And so we conclude the paper by reiterating the central point, which is that the Eli Lilly case suggests the potential for the investment law system to interfere with the realization of this neo-federalist vision of global IP law. And I think that's the case even though Eli Lilly lost on the merits for reasons that were talked about earlier. So that's the end of my